So, here I am, back again to talk to you about why it's important to review your estate plan. And there are a few reasons why it's important. Maybe one good one is it's an opportunity to correct mistakes. Everybody makes mistakes, so it's not a bad idea just to go back and check things out. You might have made a mistake, we might have made a mistake. We try to be perfect, but why not check it out every now and then? It's also an opportunity to adjust for changes in the law that affects your estate planning. And once upon a time, I thought this law was a pretty stable thing, but it seems to me like the pace at which change happens is accelerating at a very rapid pace. There's so many things to think about, so many things to look out for. So that's a good reason to change your estate plan, or at least review it to see if any change is necessary. And that's just the law. Think about your life over the last 15, 20, 25 years, and think about all the changes that have occurred. And since your estate plan really is all about people and benefiting people and providing for them, when their lives change, maybe you should be thinking about changing the way you provide for them. We'll go into all of these things in some detail. But before I do, I want to confess that there's no way I can cover all this in 20, 30, 35, 40 minutes. It's just impossible. So I want to alert you to the fact that there are lots of resources out there that we've worked hard to provide for you. And everything I'm going to say is also available to you in the resources that we've made public. And you should take advantage of them. Here's an example. We did what is an online complimentary estate plan review program. It's easily worth $500, $600. And all you have to do to go to it, to use it, to take advantage of it, is to click on a link, and it'll take you to a place where you can go through what amounts to a series of questions, a decision tree, really. And at the end of that decision tree, there'll be enough information to generate a customized report for you about issues that you need to think about. Probably won't have solutions. It will be an issue identifier and explain to you why it's important that you take a look at those things. Now, it's totally secure. I've provided a link in your materials to explain why I can make the claim that it's totally secure. You do not need to provide, during that course of interviews, any account number information. You don't need to provide values of assets. It's a series of questions that can alert you to issues without us getting that information. So you don't have to worry about private information being out there on the web for people to access. And if you want to, you can use a fictitious name. So the point I'm trying to make is all the issues that I could talk about tonight and that I can't get to are available to you in that online resource. And then there's 5 or 6 different estate planning and trust estates playlists that we've published on YouTube. These are complete courses on basic estate planning, on estate settlement, trust administration, on elder law, and lately on some of the most important provisions of the Tax Cuts and Jobs Act. And it's as easy as going to YouTube and clicking on some links, and you've got access to a lot of information. By the way, those playlists are all based on the seminars that we've been doing over the last 23 years. I'm working on updating them now, but you should know about them because I can't cover everything in one meeting like this. but I'll try. Let's start with a good reason to review is to identify mistakes and correct them. And so many of these mistakes have to do with the distinction between probate assets and non-probate assets. Of course, the will has a lot of instructions in it about what should happen with your assets when you pass away, who should benefit from them. But it's important for you to keep in mind that the will covers only a certain type of asset, as Liz said, the probate assets. That's the asset that you own in your sole name, and there's no designation of a beneficiary component to it. The best example of a non-probate asset is life insurance. Most people have beneficiaries named for life insurance. That's a non-probate asset. An asset that's probate is one that doesn't have such a beneficiary designation, and you own it in your sole name. So if you have all these non-probate assets out there, and they're all naming beneficiaries, that means your will instructions will become ineffective because wills don't control life insurance proceeds that pass by beneficiary designation. They don't control joint assets that are owned in survivorship so that the surviving joint owner inherits it. So it's important to try to coordinate all these different types of assets and make sure that all your assets are going in the direction that you want them to go in. So here's just an easy example because I want you to understand that the distinction between probate and non-probate is just as important for the small estate as it is for the very large estate. This obviously is an example of a modest estate. This is a single mother with one child. Her only assets are a home and life insurance policy, and she wants us to prepare a will. She has a daughter, maybe 8 years old. She wants us to prepare a will that provides that all her assets go to her daughter. And then we talk to her and you say, you really want to give it all to your daughter? Because if you do, that means when she's 18, she's going to have control of everything. And maybe that's not such a wise plan. And then we explain what trusts are and how trusts can be used to, at her death, transfer her assets to a trustee who'd have control over the assets, make investment decisions, and use it for the daughter's benefit. And she can make that trust last as long as she wants, whether it's 25, 30, 55, 70. Kind of depends on how she feels about things. I'm obviously not being serious about the 70, but it might be 25, something better than 18. Something much better than 18. But she forgets to change the life insurance that she bought when she first had her child, and without asking anybody, maybe when she was getting some not so good advice from a very green life insurance salesman, she named the daughter as the beneficiary. Well, what happens then when the client dies? The life insurance benefit is payable to the daughter, and it's not going to pass by the terms of the will. Done an end run around the will. The will becomes ineffective, and she hasn't accomplished what she wants. The daughter gets a lot of money when she's 18, and it ruins her life. So this distinction between probate property and non-probate property is behind. I really do think it's at least 80% of the errors that happen. So many people, when they pass away, we take a look at the assets and we say, oh, man, that's too bad. She didn't follow our advice about what to do with the assets. Or she did follow it, but her life changed. She acquired new assets and undid everything. It's very important to pay attention to that distinction. I want to say a few words about IRAs because they're a very special type of asset that's usually a non-probate asset. But it's a special asset because we're talking about a traditional IRA. The assets in the IRA have never been subjected to income tax before. That's because when the money goes into the IRA, when you set it up, you get a deduction for it. It sits in there, it grows, it earns interest and dividends, but all on a tax-deferred basis. So when you take it out, that's when it'll be subject to income tax. And if you don't do the beneficiary designation properly with an IRA, you miss out on a lot of benefits that could come from income tax deferral. Because that's what you're enjoying right now when you have your assets in an IRA. You're enjoying growth that's deferred, not subject to income tax. So what can you do about beneficiary designations to make sure you're going to get the maximum amount of deferral? What you want to do is make sure that when you pass away, it's not going to be subject to the default 5-year rule. Because when you pass away, the default rule, unless you fit into an exception, is 5 years. Now, if you have a $500,000 IRA that has to be paid out in 5 years, you're missing out on an awful lot of deferral potential. What would happen if you named your child as the beneficiary? Named beneficiary. Well, that's one of the exceptions. If you've got a named beneficiary, then the named beneficiary at your death doesn't have to take it out in 5 years. It can be taken out over a period of time that's measured by that beneficiary's life expectancy. So if that beneficiary at the time he passed away had a life expectancy of something like 40 years, it works something like this. Not exactly like this, but something like this. That the death benefit, the balance in the account, can be taken out over the life expectancy, and it's as if the first payment made the year after death might be 1/40th, life expectancy of 40 years, something like 1/40th. And then the next year, something like 1/39th. You get a long period of deferral. You mess up that possibility if you don't pay proper attention to the beneficiary designations. If you leave your secondary beneficiary as your estate, that's a problem. If you leave a trust as the beneficiary, unless the trust is very carefully drafted, that's a problem. You're stuck with the 5-year rule. So I just wanted to mention that IRAs are a special asset. Then there's inappropriate reliance on simple wills. You know, it's nice for somebody to tell you your life is simple. You could just give everything to your wife, give everything to your husband, don't worry about it. Now, when we talk to people and they say they come in for a simple will, then we start asking a lot of questions. And then they see, well, maybe there are some things they need to think about. Now, another resource that I didn't mention before, I did a video review of LegalZoom. LegalZoom estate planning document assembly program. And it was a lot of fun to do that, but I didn't expect to find this. I found out, this is the way not to do your estate plan. Okay? It is. I mean, I'd love to say, do it, it'll save you a lot of money. But there's no opportunity in there to get into the nitty-gritty questions. So this slide is taken from the video review I did. And actually, well, I won't, never mind. The guy here, this guy, it was kind of fun finding this guy. Oh, man. This guy. He is, when I did the work on the Tax Cuts and Jobs Act, the 20% pass-through deduction, I made up a fictional accountant. And he's the accountant. He's the accountant. But he's also the guy I used to go through the LegalZoom thing. So he's doing double duty for me. That's all I'm trying to say. He's a very interesting guy. And you can see, when we started asking him questions, he says, my youngest is only 12. What should I do about that? And my daughter's doing very well right here in her medical practice, but I don't want all the inheritance that she receives from me to be exposed to her possible malpractice claims as a doctor. What should I do about that? And his son has a difficult marriage. And why do I want to give my son a big inheritance thinking it's just going to be the subject of a divorce negotiation? The point is, simple wills are nice and they're easy, but when you do the simple will, before you actually sign on the dotted line for a simple will, somebody should be asking you these questions, or you should be asking them yourself. Or if you go to our online review thing, that will ask you those questions too. Another thing that people make mistakes about is they don't give enough attention to who they select for their executors and trustees and guardians. In the online review program that I talked about, it asks a series of, I guess there are 11 different characteristics that we think are important, and goes down the list. Now, is your selection honest and fair, and the beneficiaries will perceive them that way? Has knowledge and experience in legal, and tax, and investment accounting matters, intelligence, respect of the other beneficiaries, physically able, has time to do the job, pays attention to details, organized and persistent, emotionally stable, has good judgment. I think you have to ask yourself whether your fiduciaries have all those qualities. Now, it may be 10 years ago when you did your will or trust, that fiduciary had all those qualities. But what's happened in 10 years? Well, the marriage has fallen apart. He's developed a gambling addiction, and the creditors are after him, and his business has gone bust. Honestly, you need to think about these things. Cash needs. This also has to do with how your assets can change over time. You know, a young client might start out with a home and a life insurance policy, and that's it. That's a completely different situation than maybe 25 years later when he's done a very good job in investing in real estate. He's got all this real estate, but it's not very liquid, and he's got a big IRA. Illiquid business, real estate assets, and big IRA. And he's got debts that he wants to take care of, and maybe taxes. In Connecticut, I'll get to Connecticut tax in a little bit. But the point is, there will be cash needs. And when your estate is illiquid like that with real estate and IRAs, you can't consider an IRA a source of liquidity when every time you pull a dollar out, it's going to be subjected to income tax. So people don't pay enough attention to the tax needs. The first thing on this list has to do with succession planning for businesses. Yes, business people don't do a good job with succession planning, and they should. It's a mistake not to. Part of what we're doing at the firm, you know, as our hair gets grayer, even though nobody here is contemplating retirement, as our hair gets grayer, we are trying very hard to bring younger people along. So, in the way I look at it, Jim and Allison, they're younger people. Younger people with a lot of experience. That's really good, but we can help them. We can help them a lot. And then there's the really young people like Liz, and we need more Liz's. And we're going to be working on that. We really do think it's important to focus on this succession plan. And all businesses need to do that. So that's a mistake not to. And then both Allison and Liz have talked some about planning for incapacity, so I'm not going to go there. But, okay, here's the estate tax picture. When we're talking about cash needs, you can't leave out the tax conversation. Now, it's true that under current rules, you kind of all have been liberated, just totally liberated from estate tax concerns. For a moment, you've been liberated. You can see that what happened in 2017, you can see what the exemptions were in 2018 to 2026, or what the exemption is scheduled to be. And then you see in 2026, when Liz says the current law sunsets, well, that's what happens in 2026. It snaps back to what it was in 2017. And then who knows what's going to happen, because this is such a political football. So no matter what you do, what you know is that you don't know what the rules are going to be, so you have to build in flexibility to deal with these things. And that's the federal part. And I hope it is. I hope we're all liberated from federal estate tax concerns. But I wouldn't bet on it. And now Connecticut. Connecticut's interesting. Liz mentioned how the Connecticut exemption is being phased in, but it's a little bit more interesting than that, because somehow or other the Connecticut legislature has enacted 2 different estate tax laws, and the governor signed both of them, and they're different. And so, when you get right down to it, we don't know what the estate tax law is going to be in 2020. Now, they're going to get together and they're going to do something, but we don't know what they're going to do. The Department of Revenue Services is apparently taking the position that the one that really matters is this one. And that's the one that ultimately will be keyed into the federal exemption in 2023. But don't forget, in 2026, that federal exemption is going to snap back to something more like that. So we don't know what's going on. I say that not seriously. We know what's going on. It's just that we don't know how it's going to end up. So what happens? Here's an interesting situation, because lots of you, some of you, maybe lots of you had wills that were done, some in 2006 to 2008, something like that, when the estate tax exemption in Connecticut was $2 million. And we advised you a good plan would be, when the first married couples, now we're talking about married couples, when the first spouse passes away, carve out an amount equal to the exemption, $2 million, and put it in a trust. And so it's a formula that's based on the exemption. So in this example, $2 million, out of this $6 million, $2 million goes to the trust, $4 million, which is everything else, goes to surviving wife. But what happens when the law changed? When the law changed and the exemption went up, a federal exemption, let's say this is all based on the federal exemption. Doggone it. What happened? Much more went to the exemption trust, much less went to the surviving spouse. Surviving spouse has been, in a sense, disinherited. We don't want our clients to have surviving spouses who are surprised in this way. We think it's bad for business, and it's bad for the surviving spouse's emotional health. So we're trying to get the word out that people who have these types of formula wills need to change. And then when the exemption went up again under the Tax Cuts and Jobs Act, the exemption is $11 million. That sops up everything and would put it in the trust. And then the spouse is completely disinherited. Now this is sort of an exaggerated situation. Nobody has assets set up, I don't think, in a way that would have this result. But the point is, it's possible. It's very likely that people who have these types of wills will be affected by the types of shifting from spouse to exemption trust as the exemptions go up. So we really want you all to pay attention to that. But I think we're not getting the word out. We're trying hard, but we're not getting the word out. Now, there are documents that clue in, that revolve around formulas that use the federal exemption, and it might be when dealing with charitable dispositions, and also a thing, just generation skipping dispositions, which I won't get into. But if you've got a document that uses a formula that revolves around the estate tax exemptions, you've got to be thinking, that needs review. Alyson's going to be talking about, to some extent, government benefits and how an inheritance, if you're giving property to somebody who's on some sort of public assistance, how that might affect their ability to get the assistance to keep the assistance. So that's part of the conversation possibly when we're going through a review. Liz talked about powers of attorney, healthcare, revocable trust. One thing about powers of attorney and healthcare instructions, it seems like our legislature has had law changes in those areas, maybe 4 times in the last 7 years. There have been a lot of changes, so it makes sense to review. And obviously, as your estate increases in size or decreases in size, it might change the way you look at your estate planning, and you might want to review it. And we talked about already how the types of assets that you have in your estate can change the way you view your estate plan and divorce and separation. So here's an issue. Lots of people have been leaving Connecticut. It makes me sad, but it's true. And they've been leaving for places that don't have estate taxes, which is their right. If that's what you all want to do, save some taxes. I happen to believe Connecticut's beautiful. I think the taxes would have to get a lot higher for me to consider leaving. Besides, I don't want to retire. But there are strong incentives to leave. One of them being the tax picture, estate tax in Connecticut. Now that's changing, thank goodness. That $2 million exemption is going up. The income tax situation is still bad. What I want to point out is, if you do change your residence, but you keep some real estate up here, it's not like you're done with Connecticut. Connecticut isn't done with you. If you have real estate up here, but you've tried to change your residence, then just because of the way the probate proceedings work, what you have to do to clear title in Connecticut, the Department of Revenue Services is going to find your real estate that you left behind when you passed away, find your Connecticut real estate, and you will be embroiled in an audit if there's any tax to be had. So, and we've had some very difficult audits. They're ongoing. And the Department of Revenue Services is relentless in the types of information they ask for you to give them to prove that you're not a Connecticut resident. So what's the solution? The solution is make sure you don't have real estate in Connecticut. And one way you can do that is consider transferring your Connecticut real estate to an LLC, limited liability company, when you move out of state. And that kind of converts the real property into something that's not real property. It's intangible property, personal property, which probably, at least for now, solves the problem. But many states have found ways to deal with that so it doesn't solve the problem. Reviews, remarriage should trigger a review. When you're planning for a blended family, do you really want to give everything to your second wife who might not care to leave anything to your children from the first wife? These are things that you need to think about. Of course, birth of another child, if you're young and you're still having children, birth of another child is an opportunity to think about, did I name the right guardian? Maybe Susie Smith was a good guardian when I only had one child, but she's got 3 kids of her own, and I've just had another child. Maybe I should at least rethink that. I'm going to skip through a couple of things because I know Alyson's going to deal with those incapacity issues. I did want to talk about the Tax Cuts and Jobs Act. I think I mentioned, once again, there's videos. I've got right now it's 2 parts on the Tax Cuts and Jobs Act. And the second part is on the thing I wanted to mention, because it's going to have planning implications. For anybody who has income that's derived from a trade or business, that's not salary. Okay? That means you've got pass-through income, which the statute calls qualified business income. And this may shock you, but you really do get a deduction equal to 20% of your pass-through income, your qualified business income, under certain circumstances. And I just want to point out, now this is available in 2018, and you need to talk to your accountants to find out if you can maximize that deduction. And there's some strategies that you can use to maximize the deduction. One of the problems with this deduction is it gets phased out. For a married couple who has joint taxable income of over $315,000 to $415,000, it gets phased out there. And so, and if you're in that area, that phase out means the marginal rates can be very high. So if you want to take advantage of the deduction, maybe you should find ways to get your income down without sacrifice to you. So I think that people are going to be changing the types of retirement plans they have so they can put more money away in their retirement plan, get their taxable income down so they can get the benefit of the 20% deduction for qualified business income. They're going to be making investments in business assets or business equipment to get the business income down. There's going to be other strategies, but this is the one that's going to concern trust estates and estate planners the most. If you've got a business that's churning out qualified business income and you're in danger of missing out on the full deduction because you're in that phase-out zone, you might want to consider making gifts of business interest to your kids or to trusts for your kids. And these are trusts that have to be drafted very carefully, because if you make gifts of those business interests, you're basically shifting income over to them and getting below that phase-out zone. The point really is that there's so many things changing all the time, and it makes sense just every now and then to try to reassess the situation. And so I'm encouraging you to do that. That's all I have to say. I hope you found it somewhat illuminating.